The Law of Treaties. A treaty is a written international agreement concluded between states or other persons of international law and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. In English, the term a treaty is used as a generic term embracing all kinds of international agreements in written form. In addition to the term treaty, many other terms are used, such as accord, act, arrangement, charter, covenant, convention, declaration, general act, pact, protocol, statute, as well as the term agreement itself. Whatever the appellation of the agreement, it does not affect its validity under international law. Treaties can be traced back as far as the early recorded history of mankind. Evidence for their existence has been found throughout the history. Treaties have been the major legal instruments for regulating relations between states. States concluded treaties in every conceivable subject. 10 of thousands treaties have been registered with the United Nations since 1946. Until 1980, treaties had been governed by international customary law. In 1969, the Vienna Convention on the Law of Treaties was signed, codifying and developing existing customary rules. It came into force in 1980. The 1969 Vienna Convention on the Law of Treaties defines treaty as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. It further provides that it does not apply to international agreements concluded between states and other subjects of international law, or between such other subjects of international law, or to international agreements not in written form. These provisions exclude agreements between states which are governed by other than international law, agreements between states and international organizations or between international organizations, and oral agreements. The reason for the exclusion of these types of international agreements is to avoid complication and complexity if they are included in a single convention with written agreements between states, since the rules governing them differ in certain aspects from the rules governing written agreements between states. A special convention applicable to agreements between states and international organizations, or between international organizations, namely the Convention on the Law of Treaties between states and international organizations or between international organizations, was signed in 1986. However, this convention has not yet entered into force. The following sections are devoted to the rules applicable to the written agreements between states as provided by the 1969 Vienna Convention on the Law of Treaties. However, the rules provided by this convention are not inclusive. Other rules existed under customary international law continue to govern questions not regulated by the convention. Section 1. Conclusion of treaties. Treaties may be concluded by states in any manner they wish. There are no obligatory prescribed forms or procedures to be followed. Negotiating, formulating, signing and adopting a treaty are subject to the intention and consent of the contracting states. However, the 1969 Convention on the Law of Treaties provides general rules applicable to the conclusion of treaties, rules regarding the capacity and the competent persons to conclude treaties, the adoption and authentication of the texts of treaties, and the adoption of treaties. A. The capacity to conclude treaties. Under the Convention, every state possesses capacity to conclude treaties. Since states are represented by persons, the Convention provides rules to ensure that persons representing states have the power to adopt or authenticate the text of a treaty, or to express the consent of the state bound by a treaty. Such persons must produce what is known as full powers. Full powers refers to the document issued by the competent authority of the concerned state certifying that the persons represent it. This requirement is necessary to ensure the states parties to the treaty that they are dealing with the competent persons. However, there are certain persons who need not to produce the full powers. These persons are: 1. Heads of states, heads of governments and the ministers for foreign affairs, for the purpose of performing all acts related to the conclusion of a treaty. 2. Heads of diplomatic missions, for the purpose of adopting the text of a treaty between their states. 3. Representatives accredited by states to an international conference or to international organization or one of its organs, for the purpose of adopting the text of a treaty in that conference, organization or organ. B. Adoption and authentication of the text of treaties. Once a draft of a treaty has been agreed upon by the competent persons, several stages need to be followed before it becomes legally binding. First, the text of the treaty has to be adopted. The adoption of the text of a treaty implies that the form and content of the text of the proposed treaty are settled. It takes place by the consent of all the states participating in its drawing up, except the adoption at an international conference, which takes place by the vote of 2/3 of the states present and voting, unless by the same majority they decide to apply a different rule. The adoption of the text of a treaty does not mean that the participating states have expressed consent to be bound by the treaty, or that the treaty has been adopted. Second, the text of a treaty has to be authenticated. Authentication is a procedural step whereby the text of the treaty is established as correct and genuine, and not subject to alteration. It is necessary to enable the states parties to the treaty to know definitively its content so that there will be no confusion as to its exact terms. The authentication of the text of a treaty takes place according to the procedure provided in the text or agreed upon by the states participating in its drawing up. Failing such procedure, authentication may take place by the signature ad referendum or initiating by the representatives of the participating states. C. The adoption of treaties. A treaty has to be adopted by the participating states to become binding upon them. States adopt a treaty by giving their consent to it. The consent of the states parties to a treaty is an essential factor because states are bound only by their consent. The consent may be expressed by signature, exchange of instruments constituting a treaty, ratification, acceptance, approval or accession, or by any other means if so agreed. 1. Consent by signature. A state may be regarded as consented to a treaty by signature when the treaty provides that signature shall have that effect, when it is established that the negotiating states were agreed that signature should have that effect, or when the intention of the state to give that effect to the signature appears from the full powers of its representatives or was expressed during the negotiation. Signing the treaty means officially affixing the names of the representatives of the contracting states. The act of signature is usually a formal event. Often in important treaties, heads of states formally affix their signatures in a ceremony. Usually in multilateral conventions, the representatives of the participating states sign the treaties during a special closing session held for that reason. 2. Consent by exchange of instruments constituting a treaty. A state may be regarded as consented to a treaty by an exchange of instruments constituting a treaty when the treaty provides that the exchange of such instrument is that effect, or when it is established that the states were agreed that the exchange of the instrument should have that effect. Nowadays, often each state signs an instrument constituting a treaty and sends it to the other state, or states, for its signature. 3. Consent by ratification, acceptance or approval. The signing of the treaty by the representative of a state is either a means of expressing the final consent of the state to be bound by the treaty, or an expression of provisional consent subject to ratification, acceptance or approval. The effect of signature depends upon the terms of the treaty, the agreement of the negotiating states or their intention. If the treaty is subject to ratification, acceptance or approval, then it does not become binding until it is ratified by competent authority of contracting state, namely the head of the state. Ratification by the competent authority of the contracting state is a step well established historically to ensure that the representative of the state did not exceed his powers or instructions with regard to the conclusion of the treaty. It allows a state to examine the provisions of a treaty before undertaking formal obligations. Moreover, it enables a state, in the period between signature and ratification, to pass the required legislation or to obtain the required approval. The question of how a state ratifies treaties is a matter for its internal law alone. The rules related to ratification vary from state to state. The consent of a state to be bound by a treaty is expressed by ratification, acceptance or approval, when the treaty provides for such consent to be expressed by means of ratification, when it is established that the negotiating states were agreed that ratification should be required, when the representatives of the state has signed the treaty subject to ratification, or when the intention of the states to sign the treaty subject to ratification appears from the full powers of its representative or was expressed during the negotiation. Ratification occurs when instruments of ratification are exchanged between the contracting states, or are deposited with the depository. In the case of multilateral treaty, it usually provides that the instruments of ratification should be deposited with the state or the international organization that is appointed by the treaty to act as the depository. 4. Consent by accession. In addition to signature and ratification, a state may become a party bound by a treaty by accession. Accession is a formal acceptance of a treaty by a state which did not participate in negotiating and signing it. It is possible if the treaty provides that consent to it may be expressed by accession, if it is established that the negotiating states were agreed that consent may be expressed by accession, or if all the states parties to the treaty have subsequently agreed that consent may be expressed by accession. Accession has the same effects as signature and ratification combined. It is the practice in the modern times that certain treaties remain open for accession by particular states for some periods. D. Reservation to a treaty. It is well established in the practice of states that a state has a capacity, when becoming a party to a treaty, to accept most of the provisions of a treaty or to object, for whatever reasons, to particular provisions of a treaty. This capacity is reiterated by the Vienna Convention on the Law of Treaties, which states that a state may, when signing, ratifying, accepting, approving or acceding to a treaty, formulate a reservation unless the reservation is either prohibited by the treaty or incompatible with its object and purpose, or the treaty permits only specified reservations. A reservation is defined by this convention as a unilateral statement, however phrased or named, by a state, when signing, ratifying, accepting, approving or acceding to a treaty, whereby it purports to exclude or modify the legal effects of certain provisions of the treaty in their application to that state. The effect of a reservation depends on whether it is accepted or rejected by the other parties to a treaty, and this matter differs whether a treaty is bilateral or multilateral one. A reservation to a bilateral treaty presents no problem, since it constitutes a counteroffer which may reopen the negotiation between the two parties concerning the terms of the treaty, and unless the reservation is accepted by the other party, no treaty will be concluded. However, a reservation to a multilateral treaty causes a problem because it may be accepted by some parties and rejected by others. In such a case, the Convention on the Law of Treaties provides that a reservation expressly authorized by a treaty does not require any subsequent acceptance by the other contracting states unless the treaty so provides, and that when it appears from the limited number of the negotiating states and the object and purpose of a treaty that the application of the treaty in its entirety between all the parties is an essential condition of the consent of each one to be bound by the treaty, a reservation requires acceptance by all the parties. The Convention requires that a reservation, an express acceptance of a reservation and an objection to a treaty be formulated in writing and communicated to the contracting states and other states entitled to become parties to the treaty. However, an acceptance of a reservation by a state may be implied if it has raised no objection to the reservation by the end of a period of 12 months after it was notified of the reservation, or by the date on which it expressed its consent to be bound by the treaty, whichever is later. An objection by another contracting state to a reservation does not preclude the entry into force of the treaty as between the objecting and reserving states, unless a contrary intention is definitely expressed by the objecting state. Unless the treaty provides otherwise, a reservation or an objection to a reservation may be withdrawn at any time. In case of the withdrawal of a reservation, the consent of a state which has accepted the reservation is not required for its withdrawal. It is required that the withdrawal of a reservation or of an objection to a reservation be formulated in writing. Unless the treaty provides otherwise, or it is agreed otherwise, the withdrawal of a reservation or of an objection to a reservation becomes operative only when notice of it has been received by the concerned state. A reservation established with regard to another party modifies for the reserving state in its relations with that other party the provisions of the treaty to which the reservation relates to the extent of the reservation, and modifies those provisions to the same extent for that other party in its relations with the reserving state. However, the reservation does not modify the provisions of the treaty for the other parties to the treaty inter se, that is, in their relations with each other. Entry into force, registration and depository of treaties. The Convention provides rules applicable to the entry into force of treaties as well as rules applicable to registration and depository of treaties. A. Entry into force of treaties. According to the Vienna Convention on the Law of Treaties, a treaty enters into force in such a manner and upon such date as it may provide or as the negotiating states may agree. In the absence of any such provisions or agreement, a treaty enters into force as soon as consent to be bound by that treaty has been established for all the negotiating states. When the consent of a state to be bound by a treaty is established on a date after the treaty has come into force, the treaty enters into force for that state on that date, unless the treaty provides otherwise. Normally, treaties specify that they will enter into force upon a certain fixed date or after a determined period following the last ratification. Multilateral treaties, usually, provide for entry into force upon ratification by a specified number of states. However, even when the minimum required number of ratifications is reached, the treaty enters into force only between those states that have ratified it. It does not enter into force for other states until they have also ratified it. The Vienna Convention on the Law of Treaties, for example, provides that it will come into force on the 30th day following the date of deposit of the 35th instrument of ratification or accession. Moreover, it provides that for each state ratifying or acceding to the Convention after the deposit of the 35th instrument of ratification or accession, the Convention shall enter into force on the 30th day after deposit by such state of its instrument of ratification or accession. Nevertheless, a treaty or a part of it may be applied provisionally pending its entry into force if the treaty itself so provides, or the negotiating states have in some other manner so agreed. But, unless the treaty provides otherwise or the negotiating states have agreed otherwise, the provisional application of a treaty or a part of it with respect to a state shall be terminated if that state notifies the other states between which the treaty is being applied provisionally of its intention not to become a party to the treaty. B. Registration and Depository of Treaties. After the entry of a treaty into force, the Vienna Convention requires that the treaty to be transmitted to the Secretariat at the United Nations for registration or filling and recording, as the case may be, and for publication. This requirement follows the one provided for by the Charter of the United Nations. Article 102 of the Charter provides that every treaty and every international agreement entered into by any member of the United Nations must, as soon as possible, be registered with the Secretariat and published by it. Under this article, non-registered treaty or agreement remains valid but the parties to it may not invoke it before any organ of the United Nations, including the International Court of Justice. This requirement is intended to prevent states from entering into secret treaties and in general to ensure publicity for treaties. Treaties, nowadays, are registered with the Secretariat of the United Nations which then publishes them in the United Nations Treaty Series, UNTS. The UNTS provides a useful source of reference for the conclusion and contents of treaties. In addition, the Vienna Convention on the Law of Treaties requires the designation of depository of a treaty. This designation may be made by the negotiating states, either in the treaty itself or in some other manner. The depository may be one state or more states, an international organization or the chief administrative officer of the organization. The depository has functions of considerable importance relating to keeping custody of the original text of the treaty, any instruments, notifications and communications related to the treaty, giving certified copies of the treaty and transmitting them to the concerned states receiving any signatures, instruments, notifications and communications related to the treaty, and informing the states parties to the treaty about the entry into force of the treaty. Notably, the United Nations Secretariat plays a significant role as depository of multilateral treaties. Observance and application of treaties. Once treaties enter into force, they must be observed and applied by the parties. Observance and application of treaties are subject to certain established principles and rules. A. Observance of treaties. The Latin principle pacta sunt servanda, which means that treaties shall be observed, is the fundamental principle of the customary law of treaties and the very foundation of international law. This principle is included in the preamble and Article 26 of the 1969 Vienna Convention on the Law of Treaties, which states that every treaty in force is binding upon the parties to it and must be performed by them in good faith. Another long-standing principle of customary international law included in Article 27 of the Convention is that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. According to these two principles, the parties to a treaty are under a duty to observe the treaty in good faith, and a duty not to invoke its internal law as justification for failure to perform the treaty. B. Application of treaties. Under the Vienna Convention on the Law of Treaties, the application of treaties is subject to the following rules. 1. Non-retroactivity of treaties. The Vienna Convention provides that the provisions of a treaty, unless a different intention appears from the treaty or is otherwise established, do not bind a party to it in relation to any act or fact which took place or any situation which ceased to exist before the date of the entry into force of the treaty with regard to that party. The general rule here is that a treaty does not operate retroactively. Any fact, action or situation must be assessed in the light of the rules of law that are contemporary with it, not of the provisions of the subsequent treaty, unless a contrary agreement so provides. 2. Territorial scope of treaties. The Vienna Convention provides that unless a different intention appears from the treaty or is otherwise established, a treaty is binding upon each party in respect to its entire territory. This is a general rule, but it is possible for a state to stipulate that the treaty will apply only to part of its territory. 3. Application of successive treaties related to the same subject matter. Sometimes, it happens that a party to a treaty subsequently enters into another treaty related to the same subject matter, and that the provisions of the two treaties are inconsistent, or it happens that the other party or parties to the second treaty may or may not also be parties to the first treaty. These situations raise certain problems which need to be resolved. Article 30 of the Vienna Convention lays down the rules which constitute the general guide to be followed in resolving such problems. It is still possible, however, for the parties themselves to resolve the raised problems by their mutual agreement. Under Article 30, the rights and obligations of states parties to successive treaties related to the same subject matter shall be determined in accordance with the following rules. A. When a treaty specifies that it is subject to, or that it is not to be considered as incompatible with, an earlier or later treaty, the provisions of that other treaty prevail. B. When all the parties to the earlier treaty are parties also to the later treaty but the earlier treaty is not terminated or suspended in operation, the earlier treaty applies only to the extent that its provisions are compatible with those of the later treaty. C. When the parties to the later treaty do not include all the parties to the earlier one, i. As between states parties to both treaties, the earlier treaty applies only to the extent that its provisions are compatible with those of the later treaty. 2. As between a state party to both treaties and a state party to only one of the treaties, the treaty to which both states are parties governs their mutual rights and obligations. In case of treaties concerning the same subject matter and having incompatible provisions, the presumption is that the later treaty prevails over the earlier treaty. A treaty may provide expressly that it is to prevail over subsequent incompatible treaties. This is the case of Article 103 of the Charter of the United Nations, which stipulates that, in the event of a conflict between the obligations of the members of the United Nations under the present Charter and their obligations under any other international agreement, their obligations under the present Charter shall prevail. Furthermore, a particular treaty prevails over other treaties if it includes peremptory norms of general international law, jus cogens, that is, norms accepted and recognized by the international community of states as a whole as norms from which no derogation is permitted and which can be modified only by subsequent norms of general international law having the same character. 4. Treaties and third states. The Latin principle pacta tertiis nec nocent nec praesunt, which means that a treaty creates neither right nor obligation for third states, not parties to the treaty, without their consent, is a general principle which constitutes part of the customary international law. The reasons for this principle can be found in the fundamental principles of the sovereignty and independence of states, which contemplate that states must consent to rules before they can be bound by them. This principle is codified in Article 34 of the 1969 Vienna Convention on the Law of Treaties as a general rule corollary of the principle of consent and of the sovereignty and independence of states. However, this convention states certain exceptions to this general rule. First, the Convention provides that an obligation may arise for a third state from a provision of a treaty if the parties to the treaty intend the provisions of the treaty to be the means of establishing the obligation, and the third state expressly accepts that obligation in writing. In such a case, the obligation may be revoked or modified only with the consent of the parties to the treaty and of the third states, unless it is established that they have agreed otherwise. Second, the Convention provides that a right may arise for a third state from the provision of a treaty if the parties to the treaty intend the provision to accord that right either to the third state, or to a group of states to which it belongs, or to all states, and the third state assents thereto, unless the treaty provides otherwise. In such a case, the right may not be revoked or modified by the parties to the treaty if it is established that the right has not been intended to be revoked or modified without the consent of the third state. In exercising such a right, the third state is required to comply with the conditions for its exercise provided for in the treaty or established in conformity with the treaty. Third, the Convention provides that a rule of a treaty may become binding upon a third state if it becomes a part of customary international law. An example of a treaty imposes obligation upon non-party state is the 1815 agreement concerning the neutralization of Switzerland. The apparent examples of rules which are binding upon third states as customary international law are the rules of the 1899 and 1907 Hague Conventions concerning land warfare, and the principles stated in Article 2 of the Charter of the United Nations, especially those related to the peaceful settlement of disputes and the prohibition of resorting to threat or use of force. As far as rights conferred upon third states by a treaty are concerned, there are many treaties containing provisions in favor of third states, pactum in favorem tertii. Examples of such treaties are the 1919 Treaty of Versailles, which contains provisions in favor of Denmark and Switzerland, and the 1888 Constantinople Convention, which contains provisions guaranteeing freedom of passage for ships through the Suez Canal. Section 4, Interpretation of Treaties. Interpretation of treaties is the most frequent focus of disputes arising with regard to treaties. Because language is not a perfect means for expressing legal rules, ambiguities and uncertainties in treaty texts are common phenomena. Thus, interpretation of treaties has been a major task in international law. Obviously, the parties to a treaty have competence to interpret a treaty, but other entities may perform such a task. The treaty itself may confer competence on an ad hoc tribunal, an international organ, or the International Court of Justice, ICJ. The Charter of the United Nations is interpreted by the organs of the United Nations, which may request advisory opinions from the ICJ. Interpretation of treaties is a rational process of clarifying and elucidating the meaning of unclear and ambiguous treaty provisions. Its purpose is to ascertain in good faith the intention of the parties. It is governed by numerous principles and rules developed by international tribunals, publicists, organs of international organizations and diplomatic practice. Though there is no coherent and mandatory system of rules of treaty interpretation in international law. The 1969 Vienna Convention on the Law of Treaties, however, lays down certain fundamental rules and guidelines for treaty interpretation. It contains specific provisions concerning general rules of treaty interpretation, supplementary means of interpretation, and interpretation of treaties authenticated in 2 or more languages. A. General rules of treaty interpretation. The first general rule for treaty interpretation provided by the Vienna Convention is that, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. This rule is the textual approach of treaty interpretation. The context of a treaty for the purpose of interpretation comprises, in addition to its text, including its preamble and annexes, any agreement and instrument related to it and made in connection with its conclusion. Together with the context of a treaty, should be taken into account any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation, and any relevant rules of international law applicable in relations between the parties. The second general rule for treaty interpretation provided by the Convention is that, a special meaning shall be given to a term if it is established that the parties so intended. This is the intention of the parties' approach of treaty interpretation. However, there are other established approaches of treaty interpretation not provided for in the Vienna Convention on the Law of Treaties. Among these approaches is the principle of effectiveness, which involves the interpretation of the terms of a treaty in a way that will render the treaty most effective and useful. This principle is of particular importance in the interpretation of multilateral treaties establishing international organizations. B. Supplementary means of interpretation. The Vienna Convention provides that recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, when the meaning resulting from the application of the above general rules needs to be confirmed, or when the interpretation according to the said general rules leaves the meaning ambiguous or obscure, or leads to a manifestly absurd or unreasonable result. C. Interpretation of treaties authenticated in two or more languages. In case of a treaty authenticated in two or more languages, as often happens with multilateral treaties, the Vienna Convention provides that when a comparison of the authentic texts discloses a difference of meaning which the application of the provided general rules and supplementary means of interpretation does not remove, the meaning which best reconciles the texts, having regard to the object and purpose of the treaty, shall be adopted. Nevertheless, the Convention provides that the treaty may provide or the parties may agree that, in such a case, a particular text shall prevail. Section 5, Amendment and Modification of Treaties. Although amendment and modification of treaties are two processes share a common name which is an alteration or revision of a treaty, they are two separate processes accomplished by different manners and subject to different rules and conditions. Amendment relates to a formal alteration or revision of certain treaty provisions or the treaty as a whole, affecting all the parties to that treaty. Modification relates to an alteration or revision of certain treaty provisions as between particular parties only. Thus the 1969 Vienna Convention on the Law of Treaties deals with these two processes in separate articles. A. Amendment of Treaties. The Vienna Convention refers to three manners to accomplish amendments to treaties. The first manner is that a treaty may be amended by agreement between the parties. In such a manner, the rules described by the Vienna Convention which are related to the conclusion and entry into force of a treaty will be applied. The second manner is that a treaty may be amended in accordance with the procedure laid down in the treaty itself. Multilateral treaties, particularly those establishing international organizations, normally provide detailed procedure for amendments. The Charter of the United Nations, for example, lays down in Articles 108 and 109 the procedure for its amendments and revision. Under these articles, such amendments or revision shall take effect when adopted and ratified by 2/3 of the members of the United Nations, including all the permanent members of the Security Council. The third manner is that a treaty may be amended in accordance with the basic rules of procedure described by the Vienna Convention. The Vienna Convention specifies that any proposed amendment must be notified to all contracting states. All contracting states shall have the right to participate in the decision as to the action to be taken in regard to such proposal, and in the negotiation and conclusion of any agreement for the amendment of the treaty. Every state entitled to become a party to the treaty is also entitled to become a party to the treaty as amended. The amendment will not bind any state already a party to the original treaty which is not a party to the amending agreement. Any state which becomes a party to the treaty after the entry into force of the amending agreement, unless it intends otherwise, is considered as a party to the treaty as amended in relation to parties bound by the amending agreement, and as a party to the unamended treaty in relation to any party to the treaty not bound by the amending agreement. B. Modification of Treaties. The Vienna Convention provides that two or more of the parties to a multilateral treaty may conclude an agreement to modify the treaty as between themselves alone if one of two conditions is fulfilled. The first condition, if the possibility of such a modification is provided for by the treaty. The second condition, if the modification in question is not prohibited by the treaty and provided it does not affect the enjoyment by the other parties of their rights under the treaty or the performance of their obligation, and does not relate to a provision, derogation from which is incompatible with the effective execution of the object and purposes of the treaty as a whole. The Vienna Convention requires, however, that unless in the first mentioned case or if the treaty provides otherwise, the parties in question must notify the other parties of their intention to conclude the agreement and of the modification to the treaty. Section 6. Termination and suspension of the operation of treaties. Despite the general rule that every treaty in force is binding upon the parties to it and must be performed by them in good faith, the Vienna Convention provides that a treaty may be terminated, denounced, withdrawn from or suspended. The Convention provides that the termination of a treaty, its denunciation, the withdrawal of a party or the suspension of its operation may take place only as a result of the application of the provisions of the treaty or of the present convention. The applicable rules to such instances, provided by the convention, are as such. A. Termination of a treaty. Termination of a treaty means the end of the operation of a treaty, resulting in depriving all the parties of all the rights, and in releasing them from performing further obligations, under the treaty. Under the Vienna Convention, termination of a treaty or the withdrawal of a party may take place either in conformity with the provisions of the treaty, or at any time by consent of all the parties after consultation with the other contracting states. Actually, most of the modern treaties contain provisions for their termination or for the withdrawal of a party. A treaty may provide that it shall come to an end automatically after a certain time, or at the occurrence of a particular event. A treaty may give a party a right to withdraw from it after giving a certain period of notice. where a treaty does not contain any provision regarding its termination and does not provide for denunciation or withdrawal, it will not be subject to the denunciation or withdrawal, unless it is established that the parties intended to admit such a possibility, or such a right is implied by the nature of the treaty. In such cases, however, a party must give at least 12 months' notice of its intention to denounce or withdraw from the treaty. The Convention specifies the reasons for terminating a treaty. First, a treaty may be terminated by the conclusion of a later treaty related to the same subject matter, if it appears that the matter is to be governed by that treaty or the provisions of the later treaty are so far incompatible with those of the earlier one that the two treaties are not capable of being applied at the same time. Second, a treaty may be terminated as a consequence of its breach. A material breach of a treaty which consists in either a repudiation of the treaty not permitted by the Vienna Convention or the violation of a provision essential to the accomplishment of the object or purpose of the treaty entitles the other parties to terminate the treaty. Third, a treaty may be terminated by the impossibility of performance resulting from the permanent disappearance or destruction of an object indispensable for the execution of the treaty. Fourth, a treaty may be terminated when a fundamental change of circumstances occurs with regard to those existing at the time of the conclusion of that treaty. Fifth, a treaty may be terminated by reason of the severance of diplomatic or consular relations between parties to the treaty. However, such event does not affect the legal relations established between the parties except insofar as the existence of diplomatic or consular relations is indispensable for the application of the treaty. Finally, if a new peremptory norm of general international law emerges, any existing treaty which is in conflict with that norm terminates. As regard the consequences of termination of a treaty, the Convention provides that unless the treaty provides otherwise or the parties agree otherwise, the termination of a treaty releases the parties from any further obligation to perform the treaty. However, it does not affect any right, obligation or legal situation of the parties created through the execution of the treaty prior to its termination. B. Suspension of the operation of a treaty. Suspension of the operation of a treaty means the making of a treaty temporary inoperative in regard to either all or a particular party. Under the Vienna Convention, suspension of the operation of a treaty, like termination, may take place either according to the provisions of the treaty or at any time by consent of all the parties. Two or more parties to a multilateral treaty may conclude an agreement to suspend the operation of provisions of the treaty, temporary and as between themselves alone if the possibility of such a suspension is provided for by the treaty, or the suspension in question is not prohibited by the treaty and provided it does not affect the enjoyment by the other parties of their rights under the treaty or the performance of their obligation, and is not incompatible with the object and purposes of the treaty. However, unless the treaty provides otherwise, the parties in question must notify the other parties of their intention to conclude the agreement and of those provisions of the treaty the operation of which they intend to suspend. Treaties sometimes provide for the possibility of suspension of the entire treaty or some of its provisions in particular circumstances. Under the Convention, a treaty may be suspended by the following circumstances. 1. The conclusion of a later treaty related to the same subject matter, if it appears from the later treaty or otherwise established that such was the intention of the parties. 2. a material breach of a treaty which consists in either a repudiation of the treaty not permitted by the Vienna Convention or the violation of a provision essential to the accomplishment of the object or purpose of the treaty. 3. The temporary impossibility of performing a treaty. Or 4. A fundamental change of circumstances occurs with regard to those existing at the time of the conclusion of that treaty. Suspension of the operation of a treaty releases the parties from any further obligation to perform the treaty during the period of suspension. However, it does not affect any right, obligation or legal situation of the parties created through the execution of the treaty prior to its suspension. Invalidity of treaties. Invalidity of a treaty means nullity of a treaty or its particular provisions because of the existence or absence of certain circumstances or conditions affecting its legal status. Customary international law does not provide clear and acceptable rules governing validity or invalidity of treaties. The 1969 Vienna Convention on the Law of Treaties, however, provides some general rules on this matter. This convention describes rules governing invalidity of treaties in general, grounds for invalidity of treaties, and consequences of the invalidity of treaties. A. General rules on invalidity of treaties. The Vienna Convention on the Law of Treaties provides that the validity of a treaty or the consent of a state to be bound by a treaty may be impeached only through the application of the present convention. Under the convention, a ground for invalidating, as well as for terminating, withdrawal from or suspending the operation of a treaty, may be invoked only with respect to the whole treaty, except where the ground relates solely to particular clauses which are separable and unessential, or relates to a material breach of a treaty by one of the parties. A state cannot invoke a ground for invalidating, as well as for terminating, withdrawal from or suspending the operation of a treaty, if, after becoming aware of the fact, it expressly agreed that the treaty is valid or remains in force, or it, by reason of its conduct, may be considered as having acquiesced in the validity of the treaty or in its continuance in force or in operation. B. Grounds for invalidating treaties. The Vienna Convention specifies the following grounds for invalidating treaties. 1. Manifest violation of a provision of fundamental importance of states' internal law regarding competence to conclude treaties. A violation is manifest if it would be objectively evident to any state conducting itself in the matter in accordance with normal practice and in good faith. 2. Lack of the state's representative appropriate full powers. 3. Excess of authority by the representative. Such an excess will be a ground to invalidate a treaty if the specific restriction imposed by the state upon its representative to express its consent to be bound by the treaty was notified to the other negotiating states prior to his expressing such consent. 4. Error. A state may invoke an error in a treaty as invalidating its consent to be bound by the treaty if the error relates to a fact or situation mistakenly assumed by that state to exist at the time when the treaty was concluded, and that fact or situation forms an essential basis of its consent to be bound by the treaty. If the state in question contributed by its own conduct to the error or if it was put on notice of a possible error, it is not allowed to invoke such an error as a ground for invalidating its consent. An error relating only to the wording of the text of a treaty does not affect its validity. 5. Fraud. a state may invoke the fraud as invalidating its consent to be bound by the treaty if it has been induced to conclude that treaty by the fraudulent conduct of another negotiating state. 6. Corruption of a representative of a state. A state may invoke the corruption of its representative as invalidating its consent to be bound by the treaty if the expression of its consent has been procured through the corruption of its representative directly or indirectly by another negotiating state. 7. Coercion of a representative of a state. Acts or threats directed personally against a representative of a state as an individual in order to procure the expression of a state's consent to be bound by a treaty render such expression of consent without any legal effect. 8. Coercion of a state by the threat or use of force. A treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. 9. Conflict of the treaty with an existing and emerging peremptory norm of general international law, jus cogens. A treaty is void if, at the time of its conclusion, it conflicts with a peremptory norm of general international law. If a new peremptory norm of general international law emerges, any existing treaty conflicting with that norm becomes void and terminated. C. Consequences of invalidity of treaties. The consequences of invalidity of treaties vary according to the nature of the ground of invalidity. The Vienna Convention makes a distinction between void and voidable treaties. In cases of lack of full powers, coercion of a representative, coercion of a state and conflict with an existing and emerging of peremptory norm of general international law, the treaty is void, which means that the expression of consent of the state to be bound by the treaty is without any legal effect from the beginning, ab initio. In cases of violation of the internal law of the state, excess authority by the representative, error, fraud, and corruption of the representative, the treaty is probably voidable rather than void. The treaty is valid until the state claims that it is invalid. The state may invoke the ground to invalidate the treaty. However, this right may be lost for the following reasons. A. If after becoming aware of the fact, the concerned state expressly agreed that the treaty is valid or remains in force, or it, by reason of its conduct, may be considered as having acquiesced in the validity of the treaty or in its continuance in force or in operation, or B. If the concerned state contributed by its own conduct to the error or was put on notice of a possible error. The Convention provides that an invalid treaty is void and without any legal effect. If acts have nevertheless been performed in reliance on such a treaty, each party may require any other party to establish as far as possible in their mutual relations the position that would have existed if the acts had not been performed. Acts performed in good faith before the invalidity was invoked are not rendered unlawful by reason only of invalidity of the treaty. Section 8. Procedures to be followed with respect to invalidity, termination, withdrawal from, or suspension of the operation of a treaty. The Vienna Convention provides that a party invoking a ground to invalidate a treaty, terminate it, withdraw from it or suspend its operation, must notify, in writing, the other parties of its claim and give them time to make objections before it takes any action. If after the expiry of a period which shall not be less than 3 months from the receipt of the notification, no objection has been raised by any party, the party making the notification may carry out the measures it has proposed. If, however, objection has been raised by any party, the parties must seek a solution through the peaceful means indicated in Article 33 of the Charter of the United Nations. If no solution is reached within 12 months, the dispute is to be submitted to a special conciliation commission set up under an annex to the Convention or, in cases of dispute involving peremptory norms of general international law, to be submitted to the International Court of Justice, ICJ. Under this treaty, the representatives of states in universal international organizations enjoy similar immunities to those provided in the 1961 Vienna Convention on Diplomatic Relations. They enjoy immunity from criminal jurisdiction, and immunity from civil and administrative jurisdiction in all cases, save for certain exceptions. The mission premises, archives, documents and correspondence are inviolable.